today we're very fortunate and honored to have Professor Sean Boutnish give a talk on his latest research project. I understand this is your latest research project. You have so many of them. Okay, one of them. Um, so Professor Boutnish is a professor of law at Columbia Law School, specializing in intellectual property law theory as well as legal theory. Um, in my opinion, he has published the largest number of copyright law articles, and he's absolutely the foremost, scholars on American copyright law. And I could hardly figure out anyone else who has published uh, copyright articles 3 times in Harvard Law. Maybe it's 4 times now. Yes. So, and he has applied various kind of theories to study copyright law, ranging from law and economics to legal philosophy. And he has also been working a lot on IP and private law. And this is a very important, area of intersection that he has been developing. And today we're so fortunate to have him share his project on legal internalism by applying behavioral theory. So without further ado, please join me in welcoming Professor Boutnish to give today's talk.
Thank you, Houchin, for those warm words. Thank you to HKU and Professor Kelvin Lowe for having me at this workshop. And thank you all for coming. So this paper is a series of projects that are co-authored with my law school classmate and friend who's on the faculty at Yale, Taisu Zhang, where we've been working on a theory of legal reasoning and an intellectual history of the development of legal thinking in the United States and then now globally, what we call legal internalism. And this paper is in some ways the third, a culmination in a series of trying to test one of the core strands of the theory of legal internalism as it applies to a more general account of the divergence between legal practice and the legal academy. And so for me to explain what this paper is about, I want to spend a little bit of time setting the stage for what legal internalism is, some of the things we've talked about in our prior work, navigate a couple of important things, because I see some prominent legal theorists in the room, talk about how legal internalism is a little bit different from some of the established accounts of modalities of analysis or modes of adjudication that are commonly identified, certainly in the US Legal Academy or beyond, like legal formalism or legal realism. Then talk a little bit about the intellectual history and the trajectory of what we think legal internalism really captures before getting to the core element of this project, which is really the thesis of what we call the internalist drift. Okay, so the core idea for this originated now 5 or 6 years ago when Taisu and I began talking about why is it that when we start examining the way in which theorizing happens in certain fields in certain countries versus the way in which theorizing happens in the United States around certain topics, there's a fundamental difference. Our first paper on this, I was telling people at lunch today, was in theory a book review of a few prominent books that had been published in copyright law about 5 years ago, attempting to develop the history of how copyright had evolved. One was an account of American legal history, the other was an account of Chinese legal history, and the third was another kind of socio-technological account of European copyright history. And the argument we made in the book review, which really formed the launching point for this theory, was how these historical accounts were always an effort to try to tell the story of the evolution of doctrine from outside the world of the doctrine, from trying to explain how, for instance, there were some sociocultural factors or technological factors or economic factors that drove the evolution and directionality of copyright doctrine in a certain way, right? So whether it was a political economy story, some kind of Pareto efficiency evolutionary story, some kind of cultural story, But what was singularly missing in our account in these historiographies of copyright was what we came to describe as a legal internalist account, which captured the way in which participants within the practice that was being described could be seen, and I want to use my words very carefully, could be seen as engaged in a practice, even if they didn't. And there's a little bit of irony in the term legal internalism here, because we're not saying that they've internalized it as a belief structure, but the way in which they adopt their mode of reasoning to explain limitations and constraints on the direction of doctrine represents, in our view, three core elements that we see as embodied in the way in which they reason, right? And these three core elements eventually form the basis of what we describe as legal internalism. So one is the presumptive normativity of law, the idea that legal doctrine is independently normative, the reason to follow the law, even if it's not the full-blown autonomy of the law, is in many ways, if not predominantly, internal to the law. So the reason you follow the law is not because it is in your self-interest as a rational actor, but because the idea of it being the law in a certain way has a certain embodiment on the normative power that it exerts on you. The second one is that and these three factors and variables, we want to be very clear, are closely interconnected, but we nevertheless think that they're analytically independent. The second one is that the system within which this normativity operates is seen as epistemologically self-contained. Now, the epistemological self-containment is obviously an important component to the very functionality of normativity, which is that it says recourse to explaining the reasons for the normativity, or indeed reasons for a story for why a certain thing is a certain way in legal doctrine, is by reference to some other component internal to the system, right? So it's just like saying, oh, the reason we have this rule is not because it's the most efficient rule, but there's something internal to the structure of the law that necessarily justifies it. So the epistemological justificatory self-containment, in a certain sense, a closed system component, is critical for us. When we initially made this argument, for those of you familiar with it, you will start seeing, and we got this especially from German legal scholars, oh, isn't this just Niklas Luhmann? Isn't this just Luhmannian closed system? And I think I want to say there's a certain element of absolutely yes, but then I also want to hit the pause button. For those of you familiar with Niklas Luhmann, we are not embracing full closed system autopoiesis or any of those other evolutionary stories that are written about and that the German legal scholars love to talk about ad nauseum. So don't think about any of that. When we're talking about epistemological self-containment, it's a much simpler component of the fact that the reasons for the justification of a rule are internal to the system. The third component of legal internalism is that the system is seen and treated by participants, right, as internally coherent. I think this is a very, very important component, because you could see participants in the system technically saying, oh, it's normative, it's epistemologically self-contained, but yet lacks a coherence. There's a presumptive coherence in an effort to try and harmonize. So this is built into the way in which there's reasoning, right? So there's an element of what we might call presumptive systematicity in the way in which reasoning happens within internalism, right? So if you think back to Jeremy Waldron's famous critique of Felix Cohen, right, the persistence of system in the law, I think there's an element of how that is embodied in the practice of what we describe as internalism. Okay, so these were the three components that we said was legal internalism. But now I want to come to what I think is the important evolutionary story. So if you heard what I'm saying right now, your immediate reaction is probably going to be, so this is all great. How on earth is it different from legal formalism? How is it different from legal formalism, which is the way in which one thinks about internal things? And formalism today has so many different branches. You have obviously the initial branch of the Langdellian formalism. You have the new Kantian branch of Weinrebian formalism. And then you have sort of the public law formalism of the textualists and the originalists who claim we're all formalists now. So let me just now give you a little bit of intellectual history and trajectory of how we see the landscape of formalism, how we're situating ourselves, because it's important for this paper. And especially when we're noting that legal internalism we describe as not just a mode of analysis, not just a mode of thinking, but as a behavioral phenomenon. So before I come to this paper, let me just digress a little bit to tell you. So in that first paper, our account was that copyright historiographies are singularly deficient when they do not embrace the reality that legal internalism is a constraining effect on the evolution of doctrine. Okay, that was our core idea. So in other words, the point we were making was You cannot explain copyright law and its evolution without looking at the way in which copyright's internal doctrinal structure of exclusive rights, for instance, has in and itself influenced the trajectory of copyright doctrine. Right? If you just simply say, I mean, it's a core proposition for any of you who are familiar with copyright, which is, oh, if copyright is only about economic incentives, if the only reason we have copyright is to give people an incentive to create a work, then why not just pay them pots and pots of money? You create a good work, just give them, in other words, you could make an argument that a prize system is the most efficient way of creating the same incentive. The idea of exclusive rights and the grounding and the mannerism that that plays has constrained in an important way the evolutionary story. That was a descriptive account of that first paper. Then the next paper that we wrote on legal internalism was in some ways the bolder paper where we said, look, legal internalism is actually also a mode of legal reasoning. Okay. So in other words, it's a mode of legal reasoning that is in many ways distinct from formalist reasoning and is also different from what we might call the realist adjudicatory enterprise. And this forms the basis of the initial part of our paper that is what I'm presenting now, the behavioral account. But this mode of reasoning translating into the behavioral account is very, very important. So let me take a step back and now situate this to understand the mode of analysis point, as well as in this paper, the internalist drift account, differentiating it from formalism, right? So let's backtrack and rewind time. The term legal formalism has a lot of different meanings, but I think the original story of legal formalism is a historical story to explain a set of ideas that came into existence around the time that post-Civil War in the United States resulted in the development of what we might say legal consciousness for the first time, the recognition that the law is in and of itself an embodied system. People saw the embodiment of this version of formalism, which I will be the first to confess was used in a largely pejorative, negative sense in the writings of people like Christopher Columbus Langdell. And the core idea here was that the law is an autonomous system. To understand the law, you need to be trained in the law because there's something about thinking like a lawyer, which is very different from thinking like a social scientist, different from thinking like a doctor. And that in some ways, there's a very crucial yet discrete and dispositive autonomy in the way in which the legal system actually evolves and works. Now, why is what we are saying different? So let's take this version of legal formalism that existed, whether it's caricatured or real, right? Because one of the things, and I don't want to get into this debate certainly for this paper, but one of the big questions that has become sort of a mainstay of a cottage industry within jurisprudential circles in the United States today is whether there were formalists at all. Did they really do this, or was it all a pejorative post hoc rationalization by the legal realists who are trying to characterize the formalists in order to set up their own theory? I want to leave that to a side because one of the things that we see as a constant, and we make this clear in this paper, is that legal formalism, either as embraced by the people who celebrate it or as embraced by those who decry it as being the biggest failure of the legal system, was that it was a mechanism of internalized belief, right? That is a crucial, crucial component, right? In other words, the legal formalist, the prototypical legal formalist, believes that the law is an autonomous system, that there is such a thing as thinking like a lawyer, that in other words, epistemological self-containment is a real embodiment of this mechanism of law as science, okay? What we are claiming, and this is the crucial divergence from legal formalism, is that legal internalism is not a system of belief. Legal internalism is in some ways a system of practice. In other words, you don't have to believe that the law embodies these three characteristics, right? Of normativity, epistemological self-containment, and internal coherence. You just need to outwardly manifest it. You just need to outwardly manifest. Now, I want you to recognize the import of that, right? Because that tells you you don't need to be a legal formalist to be a legal internalist. And very importantly, it tells you you can also be a legal realist and be a legal internalist. Because you can believe that the law is not really all of these things, but there is some kind of a constraint as a matter of the practice of the profession that forces you to translate all these other things into the outward manifestation of these three attributes. Okay. So what we did in that second paper was to explain why legal internalism is actually an independent modality of reasoning that allows the translation or the realization of rules as playing an important role, despite the possibility that there is more than just the rules and the normativity of law that is playing a certain role in the legal reasoning in and of itself. Okay. That was in the second paper. But I think the crucial point that I want to emphasize and underscore, which is critical to understanding this paper, is this behavioral disjunct. Because without that, legal internalism collapses into legal formalism. Instead, I want to really, really emphasize the point that legal internalism is a broad tent in which you can be a legal formalist, but you can also be a legal realist. The key idea is the manifestation of these three artifacts. Okay. Now, the point that we want to make, and just as a little bit of a historical aside for those of you interested in intellectual history, and I know Dan and others have written about a lot of this. For us, the prototypical legal internalist is in some ways someone like Judge Learned Hand. Okay. Judge Learned Hand, just as a matter of intellectual history, as many of you will know, is very prominent U.S. Court of Appeals judge, never the greatest judge to have never reached the U.S. Supreme Court. Okay, is in many ways how he's often described. But Learned Hand sits on the U.S. District Court and then the Second Circuit Court of Appeals from 1909 to about the 1960s. And why is this era very important? Because this is the era of the heyday of American legal realism. And if the one thing we know about American legal realism, if they had one common denominator, it's the fact that there is a limited determinacy to the law. In other words, the autonomy of the law is not something that we can take for granted, right? So if we take that as a common baseline, what we then start seeing is a lot of the prominent legal realists were people who were surrounding Learned Hand, including people on the court at the time, like Jerome Frank and Charles Clark. And Learned Hand was in some ways being bombarded extensively with legal realism. And he developed this very weird visceral reaction to legal realism. So one time in court, some lawyer came in and started making an argument, and halfway through said, "And Your Honor, you know, because as a legal realist, we have to accept this reality." He just blows up at the lawyer. He has what he later describes as an intemperate outburst at the lawyer, saying, "How dare you use that term in my courtroom?" And then privately, someone else writes him a letter. This is actually another judge, Joseph Hutchins, writes him a letter saying, "You really, Learned Hand, you don't believe anything about legal realism? And how about, here's my article." Because he had just written a very famous article about the role of the hunch, right? And he sends it to Learned Hand. And Learned Hand, very interestingly in this observation, says, "Okay, I want to confess, I don't think legal realism is false. But I can never admit that legal realism is the dominant way because I don't want people to believe, the outside non-legal people to believe, that the law is only ever in the individual subjectivity of the human being who is discussing it. I want people to understand and confirm the idea that the law is more majestic an enterprise than just what individuals make. And therefore, I think I made a mistake, but I want you to see, I know there's something out there." Now, for us, someone like Learned Hand epitomizes the legal internalist mindset, right? Because he doesn't know whether he's a formalist, he doesn't know whether he's a realist, he's sort of in between the two. But what he is unquestionably is an internalist, right? He is very much in all of his legal reasoning, accepting the normativity of the law. I mean, even for those of you who read the American tort law cases, right? The famous Learned Hand formula. If you look at the actual opinion, it is grounded in precedent after precedent after precedent and theorized in actual cases and doctrine, right? It is as internalist an opinion as you can get, even though someone like Posner just takes that one sentence of the Hand formula and says, "Oh, it's pure law," and it is nothing of the sort. Okay, it is a pure internalist opinion. So he commits himself in his actual practice to the normativity of law, epistemological self-containment, and internal coherence. That is legal internalism for us. Okay, so that's the baseline. I know I've gone on for about 20 minutes just telling you about what legal internalism, and I haven't even got to this paper, but I think that groundwork was a little bit essential to explain why we are distinct from legal formalism and distinct from legal realism. Okay, so what do we do in this paper? So in this paper, we try to address one crucial question, which I think we, certainly in the American Legal Academy, have not spent enough time really grappling with, which is everyone likes to hold hands in the US Legal Academy very happily and say, we are all legal realists now, right? Ever since Joe Singer made this famous observation in his book review, we're all legal realists now. We don't believe in the autonomy of law. We all accept the limited determinacy of legal doctrine. What we can't agree on is what the real determinacy comes from. Some say sociology, some say economics, but we just know that we're committed to the limited determinacy. Even if you're not committed to the indeterminacy, we're committed to the limited determinacy of law and legal rules. Okay. But what they still can't explain then is why is it that in every law school, regardless of what structure and where you are in sort of the pecking order of American law schools, they're not taught as bar exam classes. No one stands up and says, here are the 42 rules you need to know for tort law to become a practicing lawyer. No, we still say, oh, let's see if this rule is Pareto efficient. Let's see if this is Calder-Hicks efficiency. Let's see if this actually comports with Kantian corrective justice. Why do we need those conversations? What is going on? And when I say why do we need these conversations, it's not just as a matter of teaching. This is what law professors do and write, right? If you were to do an article that just says, here are the 14 rules of negligence, no one is going to publish it, but somehow if someone publishes it, it's going to be looked down upon in the American Legal Academy. And I think that's the case in across the board, right? So why is it that we have a sustained ecosystem right now in a very stable equilibrium where we accept the divergence between the legal academy and the legal profession? Now, people have theorized this. Just so you know, Richard Posner has 2 books just on this, The Great Divergence and what lawyers can do and how judges think and all of that. But what's very interesting is he never quite fully gets into an intellectual history of why this came to be. And of course, let's remember, this is Posner, the judge, who's writing all this. So he's happy to point fingers at the academy. No one else is to blame, right? Not the bar, not the bench. Our account is to say, look, if we get a little bit deeper into the reasons for why this evolved, in fact, it goes back to legal internalism. Because if we look at what legal internalism as a mode of analysis and as a behavioral account allows you to do, it makes you realize that there is an inbuilt incentive structure for the legal profession to develop in a way that adheres to legal internalisms, that each of the variables that we identify, whether it's normativity, self-containment, or coherence, plays a certain role in fostering the development of expertise. And some may call it artificial expertise, but it's at the very least, a linguistic expertise that lawyers and professionals within the legal system develop, which allows them to develop into what we might call a distinct profession with its own socioeconomic status. And to perpetuate that. Now, I want to be very clear now, and this is where Professor Zhang and I, Taisu and I, disagree somewhat. He's a social scientist. I'm a philosopher. So I don't think this is a bad thing. He thinks as a social scientist, oh, rent seeking is a bad thing. No, I think rent seeking has its own internal expertise dimensions that are critical and have a certain internal coherence to them that is independently justifiable. But I think the core idea is the same, right? Which is that legal professionals have a set of incentives to develop themselves as a distinct profession that allows for the development of this expertise and for the actual perpetuation of an element of rent seeking that causes the academy and the profession to diverge in the working of their incentive structure. And what is the internal thing that what is the interesting thing that we identify? We call this the internalist drift hypothesis. And our internalist drift hypothesis is the following, which is that this set of incentives that legal professionals, and I want to be very clear what I define as legal professionals, I mean the bar and the bench, okay? The bar and the bench versus the academy. Legal professionals have an incentive structure to drift towards and to entrench legal internalism. These incentive structures, I want to be very clear, are not just your crass economic incentives, or make some more money to keep everyone else out. It's also stronger incentives, including many of which are genuinely salutary, such as the reinforcement of the rule of law, right? So I want to keep going back to Learned Hand because he's the benign case of what I think. So why was Learned Hand worried about the majesticity of the law? or the fact that he didn't want it to be seen as just the effects of an individual. It's not because he was trying to make money. He'd made enough money and he was a big figure by then, best friends with Felix Frankfurter, all of that. It was because he was committed to this idea that there was something built into the legitimacy of the law and what we might call the rule of law as a core dynamic that is undergirded by internalism. And I think that's the same dynamic that I want us to focus on here when we talk about the salutary effects of this separation away from politics. So it's not just the economic incentives. There are strong socio-cultural incentives, right, that have to go with status. In multiple countries and jurisdictions, the profession of the law is considered one that is deeply respectable, and entry into it in and of itself signals something. That's the story of what Langdell succeeded in doing. I mean, everyone was very happy with the fact that Abraham Lincoln was a lawyer and had supposedly a certain amount of genuine gravitas in the way in which he could reason analytically and deductively. I think it's the same story that can be told beyond the sociocultural aspect into the political aspect as well, right? So when courts are able to say, oh, what we're doing is not politics, what we're doing is the law, that's a crucial component for maintaining the rule of law, right? So that's part of the reason why we explain courts reason in a certain direction using legal internalism. So we then take this idea of the internalist drift, right, which is that all structured and organized legal professions and all mature legal systems with a well-developed legal profession. This is the hypothesis. All mature legal systems with a well-developed legal profession will inevitably head towards entrenching legal internalism. This is our hypothesis. And what we try to do is to say, all right, let's look at what we would think are the 6 major legal systems. And now let me just tell you a little bit before you beat me up on this, why we chose these 6. We chose these 6 with multiple justifications for it, but I'll give you 2 foremost. The one obvious one is if you look at the total number of people covered by these 6 jurisdictions, it's a significant portion of the world. The second one is they're also what we would call independent legal traditions, right? So you could also take different legal systems, but most legal systems that are not covered here are in some ways built upon other existing legal systems. So there's a sense in which these 6 capture independent legal traditions. There are a few more. I'm not going to try and say that I'm exhaustive, right? But these 6, the idea is to show that they're mature legal systems with a well-organized legal profession, and that all of them, despite different stories of their evolution over time, despite different histories, have all, very interestingly, the legal profession, despite what we see in the academy in these different countries, has moved in the direction of legal internalism. So that's a story in the US that I sort of told you descriptively in the intellectual history. It's the same story we see in the UK, where there have been blips and efforts. You would think the birthplace of jurisprudence would in some ways see much more of a theoretical component in the way in which the profession itself would accept these ideas. But over history, whether it was with Frederick Pollock or with Austin, the pushback from the bar to the profession, to the academy, not just insulated the profession from the theory, it in fact changed the direction of the legal academy over a period of time, right, towards sort of prioritizing doctrinal scholarship. And yes, there have been blips over time. And this, again, in about 1,500 words, we have each of these case studies. They don't obviously capture the rich texture of a lot of these countries. And that's the story we tell in country after country after country. In Germany, for example, you have had blips of what we call the free law movement. But to this day, the German legal system, in its commitment to legal internalism, is singular and emphatic. Same story in Japan. In India, a more recent economy, right? You would think that there was a genuine effort to break. I mean, the reason why we included India there was just a concerted effort to break the dominance of the British legal system and to do something new. And the courts initially really, really embraced it by saying, we're going to engage in nation building. We know better than everyone else. Everyone hates the government, so they must love the courts. We'll do whatever we want. But then even there, after the first 2 decades, they began reasoning into the internalist bent, not, very importantly, for the crass economic self-interest, but for political legitimacy, right? Judicial activism came to be seen as, oh, really problematic. No, all that we're doing is the law. We're staying out of politics. So maintaining the law-politics divide was an important trope that legal internalist avoids. So that's the core story of the legal internalist drift. Again, just to be very clear, the idea is not that it is a through line, a consistent line that will never see blips. It's a story of long term stabilization. And that long term stabilization, what you will inevitably see is the directionality and the embrace of legal internalism by legal professions in all mature legal systems. Now, let me just close with one obvious objection, which some of you empirically minded might just immediately ask me, which is say, this is great. It's a theory, it's an anecdotal theory, but it's also a behavioral theory that can't be tested, right? How on earth is one to falsify your theory? How will we ever know whether what someone is saying is whether was what they believe or not? And our explanation slash rebuttal to that is I think we'll accept the important limitation that our account is an account of stated preferences, right? It's hard to measure the true revealed preference, but I think what is important for us to see is why don't we begin with the baseline of it being about revealed preference, being about stated preferences, before we make presumptions about revealed preferences? In other words, why is it that we had to quickly go to legal formalism to say people believe this instead of saying this is what they're saying? Because what we know for a fact, at least anecdotally, is that you have thousands, not even hundreds, thousands of lawyers coming out of American law schools and law schools across the world who are trained in law and economics, law and sociology, who understand that tort law is not just four rules, but there's a lot more. But when they move into the world of legal professions, they're abandoning reasoning in law and economics. No one, to best of my knowledge, ever stands up in court and says, Your Honor must accept this approach to negligence and reasonable foreseeability because it's the efficient outcome that society needs. Right? I'm ready to harbor a bet that very few, if any, legal system will allow for that lawyer to continue making the argument without the judge jumping in and saying, Excuse me. Okay. But that's the point that is at the core of this paper, which is even the hardened believer in legal realism and the external validity is forced into the mechanism of reasoning in an outward manner through the internalist edicts. Okay, I will shut up there. Happy to take any questions, comments, and thoughts.